We have, I think, Mr. John Chisholm, our district attorney, Chief Judge Trigiano, and I'm not sure if we have anybody from the Public Defender's Office who is appearing. I think we had reached out to them, but I don't see anybody on the board from the Public Defender's Office. Chief, you're muted.
Thank you, Chairman. I forwarded the invites to Tom Reed from the Office of State Public Defender here in Milwaukee. Hopefully he'll be on.
Okay. Very good. Thank you for that. So just to the folks appearing up, there's Mr. Reed.
Yep.
Okay, very good. So for the folks appearing and also for members of the public who might be tuning in and for members of the committee and the board, first of all, I want to thank Chairwoman Nicholson for expediting the creation of this file and allowing it to be on our agenda so quickly. I wanted to also thank our county clerk, Mr. Christensen, for his efforts, and also our research staff, again, for creating a file and allowing us to hold this public information gathering today as part of our agenda. As the coordinator noted at the top, this is an informational only item. We are not voting on anything today. This is simply to gather some information and inform the board and the public about some of the events concerning the tragedy in Waukesha at the Christmas parade and how those events transpired. Once again, this is not a public hearing. We have three invited speakers who will make some comments, and then hopefully we'll have time for questions from our committee and from the board. If members of the public do want to comment on this particular topic, we do have an e-comment option. We welcome e-comments. They will become part of the public record and part of our permanent record. So e-comments are welcome, but again, unlike our usual format, we will not have any citizen comments or participation on this particular item. So again, having said that, I thank the individuals who are appearing today. Why don't we just, if we start maybe with Mr. Chisholm and then go through the others, and just please introduce yourselves. I would, ask you to make some general remarks about, the topic at hand, which is our bail system, and then perhaps some more specific comments, if you can, about the particular situation. Then, and if you're willing, I'm sure our committee and our board may have some questions. So thank you for your appearance today.
Thank you, Mr. Chair. John Chisholm, Milwaukee County DA, and thank you to the members of the committee. I, like all members of our community, am angry, I am frustrated, and I'm extraordinarily saddened by the circumstances that have impacted so many people, yes, in Waukesha, but also here in Milwaukee County. And I want to thank the committee for giving me the opportunity to address the issue of bail, but I also have a practice of responding to any inquiry from the board and responding in person. And my intention is to be as candid and forthright with you as possible, addressing as many of the facts as I can related to our role, our link in the chain of a series of decisions that resulted in a tragedy. I acknowledged our involvement and our responsibility for that immediately, and I will continue to examine it very closely. And my hope is that if anything can come out of this, it's that as part of this process, we can look at the general circumstances that this community is faced with right now in its criminal justice system, the exigent demands that are on it, and try to improve it, do everything in our power to improve it with the scarce resources that we have. I want to make it clear that there are explanations for what happened. There are no excuses. I'm not here to make excuses. I own every decision that's made by any member of my office. I have to invest them with enormous discretionary decision-making power, and they exercise that overwhelmingly very well. And on the occasions that they don't, I have to explain why it didn't happen and take responsibility for that. And this is part of that process, and I'm more than willing to do so. So thank you for the opportunity.
Okay, thank you. Chief Judge Tergiano?
Yes, good afternoon. Yes, good afternoon, Chairman Stiskunis and supervisors. Thank you also for the opportunity to address this committee here today. I do want to express my deepest condolences to everyone affected by this horrible tragedy in Waukesha. I'm sorry for those who lost their loved ones, the unbearable pain and suffering of family and friends who lost loved ones, those who have been injured, and those impacted by what they saw. I know firsthand that the ripple effect of such a tragedy and tragic event is incredibly challenging and painful. I remain resolved to always look at, find ways, take every opportunity to examine the situation at hand, as well as going forward to improve our justice system. Mr. Chair, it's also my understanding that one of our supervisors has been greatly impacted by this tragic event. I offer my prayers and condolences to her and her family as well going forward. She's in my thoughts and my prayers.
Okay, thank you, Judge. And then Mr. Reed, Mr. Public Defender Reed, if you have any sort of opening comments or thoughts?
I don't usually think of myself as Mr. Public Defender, so I'm just going to introduce myself as Tom Reed. I'm the Regional Attorney Manager for the Public Defender's Office here. And what I would say, obviously I share the recognition that my two colleagues have mentioned in terms of the tremendous impact that these events have on the lives of so many people. And sometimes that's a direct impact, and of course, more, to the society at large, it's indirect, but it's very real. It affects everybody in a deep way, and it's a trauma to our community. And Waukesha and Milwaukee aren't exactly the same community, but for these purposes, we are one community. And I would just say, as a preparatory kind of introduction to whatever questions the board might have, our lawyers are assigned into our intake court about 360 days a year. And so we have attorneys every day who are appearing before court commissioners and seeing clients before they make their initial appearances. We're very familiar, have a deep and broad experience with bail setting practices in Milwaukee County. And I think we have some relevant information that might be of value. I would also say that Milwaukee stands out among a lot of places in the United States as a community that has come together to try to institute evidence-based practices and to do the best it possibly can do by using modern approaches, including risk assessment tools and other kinds of strategies. And those are very much a part of our system. They are not perfect, and this is what brings us together today is an example of it not being perfect. But I think it would be a mistake to assume that, as imperfect as this one example is, that it represents the kind of work that's being done on a daily basis in making release decisions. And I'm happy to answer any questions that anyone would have relevant to that observation. Thank you.
Okay, thank you very much. I guess for the rest of the meeting, I'll just refer to you as Mr. Reed then. I won't use your title then. If we could go back maybe to Mr. Chisholm at this point and ask you to maybe lead us through a little bit about, how this particular situation came to be and maybe intertwine with that, how the bail system works in Milwaukee County, if you don't mind.
Mr. Chair, members of the committee, yes. Let's focus first on the decision to recommend a $1,000 cash bail. That is a decision that on its face, I have already articulated and stated fairly early as this was unfolding that I believe that was inappropriately low given the context of what we knew about the defendant. And let me also make clear, I am saying this not just because it's my ethical obligation to say so, but because it also points to a really important point, and that is that anything I say right now has to be remembered in the context that Mr. Brooks is presumed innocent until the cases are adjudicated. Prosecutors are obligated to say that in any case where a charge has been issued. And it speaks to the issue of bail as well, and that is that the state ultimately bears the obligation to prove every case with evidence that supports a finding of proof beyond a reasonable doubt. The state's main power, as it were, is to issue a charge. We do not ultimately decide the outcome of that charge. It either goes to a jury trial, it goes to a court. We make arguments, we present evidence, but our ultimate power is to make a charging decision. In this particular case, the statement we released early on was to indicate that Mr. Brooks had already been arrested and charged with a serious weapons-related offense. On that case, $10,000 cash bail was set. Now the context of the enormous challenges that we are facing in relation to the pandemic come into play, because what occurred is that this defendant was held on bail and the trial dates were set. He had a trial date set that we could not provide a court trial for him or a jury trial for him on that date, but it's not because we weren't doing anything else. I think the courts can speak to what else was going on that day. But under the law, there is a requirement that a person's custody status be reviewed if you can't provide them with a speedy trial. That's what occurred. The bail was reduced in that case. Time later, Mr. Brooks is arrested again, and this time it's for a very serious domestic violence offense. This brings in the Milwaukee DA's office once again, and the decision, which was appropriate to charge Mr. Brooks with a very serious allegation and issue a criminal complaint on it. The context I can tell you from having examined the circumstances surrounding this decision is that the ADA, who is has about 2.5 years experience, but is already prosecuting domestic violence felony cases. She's one of our 2 dedicated domestic violence felony cases, has already in 2.5 years done over 20 jury trials. That week, she was actually in the middle of a jury trial, a 2.5-day jury trial, in addition to having almost 24 felony level cases to review. This case was one of those cases she was reviewing in that context. And we have established a risk assessment system in Milwaukee County, which is really important to understand. When I first ran in 2007, I made a commitment to the community that I would do everything in my power to try to identify people by risk. And those people that pose less of a risk, even though you can never guarantee that they are not going to do something more serious. But with all the information we had, if we could identify people that were drug addicted, mentally ill, lower level offenses, we wanted to do something different with them so that we would have the resources to focus on violent people that hurt other people. That was the goal. That is the system that we've put in place, and that system actually was operating and should have been followed. It should have been followed. There was a public safety assessment that was done that characterized this situation as a high-risk situation. Our default position in this case, because of the laws in Wisconsin, is that we recommend higher amounts of cash. That's not what the law says, by the way. The law says that cash is only intended to bring the person back to court, and non-monetary conditions can be considered, factoring in the dangerousness and the risk to the victim and other factors like that. Nonetheless, higher cash bail should have been recommended in this case. In talking to the ADA, what she indicated is that she did not have access to that public safety assessment. It's not because it wasn't done, it just hadn't been uploaded into our case management system. Given the volume of cases she was dealing with, given her jury trial that she was working on, she simply charged the case. She looked at the previous bail, saw that it was $500, and she doubled it. That's it. That's a mistake. That's human error. And it just set in motion a chain of events that resulted in a tragedy. And again, not trying to lessen our responsibility for that, but that's it. And there's a lot more information we have to talk about going forward, and I'm going to be as transparent and accountable for that. But in essence, that's what you had. You had a young ADA trying to do the very best she could under really difficult circumstances, and she made a mistake.
Chief Judge Tergiano, is there anything you'd like to build on from there?
Mr. Chair and members of this committee, supervisors, as I mentioned to you before, Chairman Stiskunis, I am happy to respond to any questions asked of me, but I have to preface that with the need to follow my judicial code of ethics under 60.04, which restricts me to a certain degree in talking about pending or impending cases. Having said that, I will talk more in generalities as opposed to what specifically happened in this particular situation. But I would say, and I think maybe some more background is pertinent to this discussion as well. We have 46 judges in Milwaukee County Circuit Court. 8 are assigned to Children's Court. 12 are assigned to our Civil Division, both 2 in probate and 1 in small claims. We have 6 judges assigned to our Family Division. And then if I move over to our Felony and Misdemeanor Division, which encompasses our Criminal Division, we have 14 felony judges. That is broken down by specialty. We have a judge in our Gun Court. We have 4 homicide sexual assault judges. We have 1 specialized high-intensity drug court. We have 2 general drug courts. We have 5 general felony courts, and we have 1 treatment court, which includes working of adult drug treatment court, the mental health court, as well as our veterans court. We also have 3 specialty domestic violence courts. Those 3 courts handle both felony and misdemeanor cases. And we have 4 general misdemeanor courts. Each one of them has an extremely high volume of cases pre-COVID, and certainly with the oncoming of COVID, as I mentioned in some of my appearances in front of this committee, some of those caseloads are doubled. We are handling as many jury trials as we can. Some of those jury trials go to trial, others resolve in other ways, some get rescheduled, and many of the judges, as D.A. Chisholm has indicated, are reviewing bail repeatedly to see what circumstances might occur if you have to adjourn a case for any particular reason. On the particular case, and this is public record, Judge Feist, who was handling Mr. Brooks' case, actually could not try his case when it came up because he had to try an 8-count first-degree recklessly endangering safety, possession of a firearm in violation of a domestic abuse injunction case with the team that works under John Chisholm's supervision. It was an older case than Mr. Brooks, and it had more serious charges. The trial went forward. As the record indicates, bail was set at $500 cash for Mr. Brooks at that time. Fast forward to, we also have 22 court commissioners working in our system here. 1 is working in the probate division, 10 are in our family court commissioner's office, and 11 are judicial court commissioners, which spend their time in the criminal division, in the small claims, as well as children's court. The court commissioners that spend their time in the criminal division do in-custody intake, out-of-custody intake, and traffic appearances. Those court commissioners do initial appearances and set bail. They hear cases day in and day out, high volume as well. They look when setting cash bail or any kind of bail. They look at what the DA has recommended. They look at the public defenders. If they have the public safety assessment in front of them, they look at that. They may ask further questions of both the DA and the public defender or the defense attorney, but they want to gather as much information as possible to set bail. It is on them to take all of that information into consideration and set appropriate bail. And again, they do that day in and day out. So it is in their professional discretion after the district attorney's office and public defenders give them as much information as possible.
Okay.
I'm open to further questions. I think that certainly you'll have more, and I'm willing to answer those.
Okay, thank you. Well, let's do this. Committee members, if you have any questions for any of the three persons here, please raise your hand and we'll go through those. Supervisor Ortiz-Velez.
Thank you, Mr. Chair. I want to start off by saying my heart goes out to all the families that are affected. And I want to thank all of the three people that are here to talk about this discussion. You have very tough jobs. And I've met with many of you on some of these, issues in the past that I wanted to mention. We know that Milwaukee County has been historically, racially, what I'm trying to get at, I guess, is that we know that we have current problems even before COVID-19. I know I've met with Mr. Chisholm about the underfunding of staff that has plagued that department for some time, even before COVID. We also know from Judge Trujillo's many times before our committee that we are behind in cases and we are overburdening. We have overburdened even an overburdened system already. I know that we have some serious issues, and I feel that we need to, do something about it if we can, because it's not going to get any better tomorrow or next week. We need to address these issues. I mean, I know this is just an informational, Mr. Chair, but I know that everybody wants to do the best to serve the people of Milwaukee County and for us to have a place safe to live and a healthy place to live. But we know that we've already underfunded our department, not underfunded because we wanted to, of course, because we haven't had the money as a county, but we need to focus now. We need to focus now on what we know, that we already know the problems there. We need to fix the problems. We need to give the people the tools they need right now, even more than they needed before. And I guess I have two questions. I have a couple questions for John Chisholm, the district attorney, and for Judge Trujillo. I do my best I can with your name. I'm sorry, you Judge. Mr. Chisholm, can you give this body and the public an idea of the crisis we're facing with the rise of DV cases on its own?
Mr. Chair and Supervisor, yes, the last 2 years have been a pandemic, not just on a public health scale, but it's been one of violence. And we have disproportionately seen a rise in incidents and often very, very serious and even fatal incidents related to domestic violence. That is why we have always had a dedicated and focused domestic violence unit. We work closely with our community partner, with the Sojourner Family Peace and other service providers in the community. We work closely with our law enforcement partners. We have had a national model for assessing threat and trying to prioritize those cases. But we are simply overwhelmed. We have lost, in the midst of this, we have lost 6 ADA positions since 2018. 2 of those have been from the domestic violence unit. That's because I've lost federal funding. I have approximately 90 assistant DAs that handle adult offenses that occur in Milwaukee County. Population of about 1 million people roughly, and I have 90 prosecutors that are responsible for addressing any violations of the social compact. They are broken into specific groups to focus intensely on issues like homicide, sexual assault, domestic violence, gun violations, non-fatal shootings, children in need of child protection advocacy unit, general misdemeanor, general crimes. But they are absolutely overwhelmed, as is the system right now. We generally try about 500 matters to jury or court trial every year. Because of the pandemic, we've had to constrain some of that, and that in turn affects other parts of the system. So currently you have the jail that has over, I believe, about 175 individuals in the jail just awaiting homicide charges right now. We've got another additional 100 or so awaiting first-degree sexual assault. We have an additional 70 or so who have committed serious crimes against children, and this doesn't even include the people who have non-fatally shot people, robbed people, who have been driving for the 5th, 6th, 7th drunk driving offense. We're dealing with a jail that has a limited capacity. The consent decree limits that jail to about 920 beds. I believe they currently have about 880 to 890 people in jail right now. So we're faced with triage every single day. Everything we do every day is like a triage unit. People are coming in looking for us to address the issues that surround them having been harmed by somebody else. And it's our obligation to do it. We focus intensely on trying to provide service to the victims. And as you can tell, just in this particular case, the ADA didn't make a decision just in a vacuum with lots and lots of time to assess it. Doesn't excuse it, but it puts it in context that when you're dealing with high volume triage, trying to sort what the most serious offense is and just get the case in the system and move on to the next one, sometimes errors are going to occur. One thing that can come out of this, I believe, is an honest assessment about what bail should be about. And so we don't have to talk around the issue. I have always believed that we have to do some. It's been quoted that I'm opposed to cash bail. Well, the reason I don't believe in cash bail is it doesn't do a good job of assessing risk. That does not mean I don't think that some people need to stay in custody until their case is tried. That's called the preventative detention framework, which other states have. That's what we have. We have a statute that allows for that. It is simply unworkable. If you read anything from anybody that's commented in the last week saying that, well, they should just use their preventative detention statute, they don't know what they're talking about because it doesn't work. It is not a feasible. The most practical thing about it is that you would, in effect, have to have like the equivalent of a court trial within 10 days of keeping somebody in custody, evidentiary, and then that case would get moved to the front of the line. It simply is not workable, and that's why we have never implemented a preventative detention. The simple solution is to allow us to argue honestly to the judge, to the court commissioner, why it is that we think somebody should not go back out into the community. And then that person would be detained, that case would be expedited, and you would prioritize getting that case resolved. But that's the better approach, and it's been tried in other states, and that's a direction I think we should go as a state.
Mr. Chair, do I still have the floor?
Yep, you have the floor, Supervisor. Please go ahead.
I only have one more question for Chisholm, DA Chisholm, and then just like 2 questions for Judge Trina, maybe 1 actually. Thank you for sharing 2 things that we should have an honest discussion about what bail should be about, and also mentioning what other things we should look at. But as a body, what other tools could we equip your office with to make the system better?
Mr. Chair and Supervisor, thank you for that question. You've already done that, and you do that on a regular basis. the whole framework we have in place right now that allows us to identify risks and the people that might be appropriate for a different solution is because of the board allowing us to have an early interventions program. Let me make perfectly clear, the early interventions program has nothing to do with Mr. Brooks or Mr. Brooks' case. He is not, he was not, and he would never be eligible for any of those diversion programs. Not eligible, not even in the discussion. And so the point simply is that if but there's legitimate issues that you brought up, and that is that cash bail disproportionately impacts on people who can't pay the cash bail. And that's not fair. And so ultimately what you want to do is create a system that treats everybody the same. And cash bail doesn't help you if somebody can, even through illegal means. I prosecuted a case in the early 2000s against a violent Jamaican drug organization where they had access to millions of dollars. They could have posted $1 million. So how did that keep the community safe just by asking for $1 million? So what you want to do is focus on the risk, and that's the system that I think we have to go to.
Thank you, Mr. Chisholm. Chief Judge Giugiano, I only have one question I think left is, as far as the caseloads at the courts, and I know you've kept this committee very well updated, what's the outlook at this point? Thank you.
Mr. Chair and Supervisor, thank you for that question. Yes, I have tried to keep you as updated as much as possible, including new crises that we're facing around some of the staffing shortages, and you guys have been very, very attuned and helpful in addressing some of our situation. I do want to say a couple things first related to some issues that DA Chisholm brought up. We do work with the medical college to get data and information, and it certainly confirmed our worst fears. The confluence of COVID pandemic and the increase in non-fatal shootings and homicides has really put a strain on our system, and as well as domestic violence and the increase in domestic violence cases. Since day one, as you all know, we started the venture about, we went down and we started coming right back up because we knew we had to, because we knew our volume was going to be terrific and horrific going forward. And so, by July of 2020, we were already doing jury trials. And every time we opened a jury trial or opened a courtroom, we'd open another several next months after that. So we consistently we're trying to be in recovery mode with this crisis just looming over us in terms of the volume of cases. But we paid special attention to domestic violence cases, both in the criminal and the civil side. Our civil family court commissioner, domestic violence injunction group, were in the courthouse every day. Didn't go home since the pandemic started because we knew we had addressed domestic violence injunctions on a repeated basis. Our criminal division got about 80% of all of our resources because we knew we had to start getting the cases back up and going. We put in place Zoom hearings so our volume wouldn't get higher than it is now. Currently, we are looking at a felony backlog of about 1,600 cases and a misdemeanor backlog of about 3,100. We are chipping away at it, but not very fast. We are looking at even more solutions to make sure that we can address that, including shifting some of our judges from our current divisions into the criminal division. Bringing in reserve judges, we've talked about that. We need staffing for them, so we're trying to tweak that so that we can get more hands doing the criminal cases. But again, that puts some strain on both the DA's office, the public defender's office, the sheriff. We've talked about that. But we have not sat down for a minute and taken a breath. We have consistently tried to move forward to address all of our backlogs, trying to get everyone in.
Thank you, Mr. Chair. Thank you.
Okay, thank you, Supervisor. Supervisor Logston?
Thank you, Mr. Chairman. We need to, excuse me, just trying to get my composure. It's been difficult. We need to appropriately address this COVID pandemic backlog. Congress enforces state laws and guarantee speedy trials. With this said, has the county reached out to the state to assist us with this? Have you asked for any help, extra judges, funding, additional dormitories to hold those people that we have to keep on hold that have done especially domestic violence? And as we know, the way the books show, they'll do it again. How are we protecting those innocent people on that side of it? We need to keep them in jail until their cases come up. We don't need to let them out without doing the appropriate trials. Why is Milwaukee County not back full force at the county as other municipalities are? I keep asking that. Why aren't we back full force as other counties? We need to address this. So if somebody could first answer, have we reached out to the state for help for this backlog, which is causing a lot of unnecessary incidents that have been happening in our community? Thank you.
Anybody able to answer that question?
Sure, Mr. Chair and Supervisor Logston. So we have had a lot of conversations with both state and local governments in terms of trying to address the needs for resolving our backlog. We have used CARES Act dollars provided by the county. The state, at least the court system, ceded their COVID recovery dollars to the counties so that we could address some of our backlog needs here in the county. The county, through the county board, yourselves, as well as the county exec, have given us tremendous support in terms of outfitting our courtrooms with PPE protection so that we can bring individuals in the courtroom, including jurors who we need more of and we want to protect as well when they come into the courthouse. So we worked many long hours with the county's recovery team with COVID dollars. The Office of State Courts, Director of State Courts, purchased Zoom hearing licenses across the state, but for every judge and court commissioner here and others in Milwaukee County so that we could get those cases up and running. We have also looked at the use of reserve judges, and we've been using them to the extent we can. We do have some shortages in the clerk's office, as well as court reporters. So it's hard to outfit another reserve judge to help take some of those cases. Right now, we are shifting potentially some of, like I said, our judges from our civil family division to work on some of our criminal matters. There are just a lot of issues that are impacting our ability to do cases on a regular basis. This week alone, Monday, I believe between about a half a dozen judges, there was 40 cases stacked. Now, some of those cases resolve, either a plea or a dismissal if there's no proof beyond a reasonable doubt, or a jury trial. But we are stacking cases and trying to get through them as many as we can. I know there are other issues impacting our ability to do that, from Tom's office to John's office, but it has been all hands on deck, and we will continue to brainstorm to make sure that we will move forward. I do have to say, every criminal judge has been able to go back into their courtroom as of, excuse me, September of this year. They have been processing cases. We will be opening all the jury trial courtrooms. We're crossing our fingers we get enough jurors, so I'm making a plea as well for jurors to come and do these, sit as in jury trials for us, and we need jurors from diverse backgrounds to do that. So we will all be back in and have been in the criminal division. The judges, court commissioners have been working extremely hard day in and day out processing these trials.
And if I may, Mr. Chair.
Yes.
Mr. Chair and Supervisor Logsdon, it's a really important question. And what I can tell you is that we are constantly trying to find additional funding to address these issues. And yes, I would ask and apply for example, ARPA funding to be used to not just provide additional prosecutors, but public defenders as well, and judges. But here's the challenge. Here's the fundamental challenge with that right now is that there's been long-standing neglect of the system, and if in the last since 2018, I've been always trying to be as transparent with what we do in this office and allowing people to come in, take a look at what we do. And since 2018, we've issued probably 40,000 cases or so total. And that, of course, has been severely disrupted. In that same period of time, I've lost, I think, 48 prosecutors in that out of 120, out of roughly 120. And so the economics of being a line prosecutor right out of law school or being a public defender right out of law school are so challenging right now that we can generally keep them for a couple of years, just to the point that they start becoming really effective, and then they're moving on to higher paying jobs. So there's actually a limitation right now on having enough bodies. I know that the state public defender has been struggling just to get private appointments, for example, so that we can even move the existing cases through this. This is something that we're addressing on a weekly basis. So yes, I mean, but the bottom line is I have seen other jurisdictions, I would mention Seattle, for example, that I think allocated like $10 million to the King County system to address backlogs, and that's supported 100%.
Mr. Chairman?
Yep, Supervisor Logsdon.
Okay, and I would like to also address this to Mr. Chisholm. You know, as you're aware, I support and respect our police officers and our sheriff department. They put themselves out every day in harm's way to protect us, the public. And with that said, what I really have issues with when we get them arrested and put where they belong for what they're doing. Because as you know, our vote laws have been a lot lax the last couple of years. So you have to do something pretty bad now to be put in jail or the house of correction because of the overcrowding. So to speak, you got to work on it to get in there. And so once we get them in there, it seems to be a revolving door, and they're getting out too easy. And with this said, this is why we've seen more violence. To me, this is obvious. This has to be addressed. We have to, if this is something new in the last couple of years, I keep hearing, oh, the violence is up, it's going up more. Spoke with one of my fellow supervisors this morning from the north side, and they expressed it's terrible. The speeding, the reckless driving, everything's worse. It's because our laws are getting lax, and they know it, and they're abusing it. We need to be tough. That's what law enforcement is. It's to keep up the law. I'm not going to get specific, but I know you're going to be aware of what I'm speaking of. There's an incident that happened right in my district, and there should have been people arrested. There should have been an investigation, and it wasn't done because they did something against the law. And I will be specific. Marijuana is illegal in Wisconsin, and you refuse to prosecute these people. And people are seeing this, and that is why we're having more and more violence in our county. I beg you to address this. Get a task force from another state and another municipality. We need someone out there maybe to give us more advice. We need to be aggressive. This has to stop. Thank you.
Thank you, Supervisor. Mr. Chisholm?
Mr. Chair and Supervisor Logson, I have always made the distinction, and I will make it again, that we focus almost all of our resources on addressing violent crime. That's why I have a dedicated homicide unit, a dedicated sensitive crimes unit, a dedicated gun unit. That's why almost everything that we do is focused on violent offenders. Having said that, these are truly unprecedented times. If you look at the data just as of today, there's been 179 homicides just in the city of Milwaukee. How many were there in 2020? 179. Those numbers are the highest they're higher than the highest we've ever had since 1991. The solve rate on those cases has gone down dramatically for a lot of reasons. And that's the challenge right there, is that resources are being cut across the board, everywhere. And you have to solve the case before you can prosecute it, is what I would say. So I have to prioritize. You're absolutely right. There are challenges that I face. If I have to prioritize, do I put my resources into prosecuting a homicide offense, or a non-fatal shooting, or a sexual assault of a child, or a drug dealing offense? I understand that drug dealing has consequences to a community, and we try to be responsive to that. But with the limited resources I have, I almost always try to focus on the biggest threat. And the biggest threat is that threat of people hurting other people and being held accountable. That's the work that my people are doing heroically every day. They really are. And you don't hear about the successes. You shouldn't hear about the successes. You do hear about the failures, and you should hear about the failures too. But it's not because they're not working incredibly hard to try to keep this community safe, because they are.
Mr. Chairman, may I respond?
Sure.
Mr. Chisholm, thank you for that. And thank you, Judge Trigiano, I'm sorry. I understand, and I know you guys are working hard, and I know you're working with what you have. And I know that that we even have some fellow supervisors that are trying to defund you. And this shouldn't happen. Safety of our community is my #1 concern. And I will do anything to help you to find sources to fund your departments for safety. But little things like this, the gentleman that we're all here for, I'm not sure if we can say names, so I'll just say the gentleman, but being kind. He was let out on bail. If you shoot somebody and you're let out on bail, you make sure that you take that gun away from them. Well, his weapon was a vehicle. Why didn't we take that vehicle away from him? These are things I ask. I just wonder. He got the vehicle back, and he's already, was out on bail and not even tried for that incident as yet. Just these questions that are just going through my mind. This could have been avoided if the court system would have caught this. I'm not putting my finger on anybody and saying it's your fault, but I want to see this prevented in the future. Thank you.
Mr. Chair and supervisors, I put the finger on myself, and that's my obligation. That's my responsibility, and the things that you're pointing out, they're real. And the only way you can approach it, what I learned in the Army was that when something bad happened, that you had to evaluate it, and you had to actually elevate the bad things. You talked very little about the good things, because the good things, those are expected. What you had to train for and prepare people for were the negative outcomes, the things that didn't go right. And then you have to elevate those for one reason. It's not to blame people. It's not to shame people. It's to prevent it from happening in the future. And that's what I'm committed to. So as part of this particular incident, or as a part of a general review of bail, I'm committed to coming forward in the future and providing you with additional information. There's a process called Sentinel Event Review, for example, where you can break down everything that happened, all the failures, all the successes, the things that went well, the things that didn't go well, And then you present that with one goal, and that is don't let it happen again. That's what we're committed to. We have great working relationships within the system, and I'm committed to doing that on this case and presenting. There's a lot of other information out there about our system, because we do capture a fair amount of information, and we're always willing to be transparent about that. So I'm just making the commitment that I'm happy to come back to this committee and provide additional information, both specifically related to this case, but also on the broader issue of bail.
Thank you, Mr. Chisholm, and I appreciate what you just said, and for our committee and for our board and for the participants today. Again, I would just say that I view today as our first meeting, not our last meeting. This is the first conversation that we're having, and I do believe that we will be following up, and let's continue to have the conversation as we move forward. Supervisor Shea.
Thank you, Mr. Chairman. District Attorney, Chief Judge, Mr. Breed, as we all know, we are here because of what happened at the Waukesha Parade. Now, as I reminded my fellow supervisors many, many times, when I first ran, the biggest problem I heard was cynicism. There is a great deal of cynicism in the community about government in general, and right now, no doubt, there's a great deal of cynicism about our court system. Now, if someone says to me, our court system's not working and it's just a revolving door putting violent criminals out on the street, what should I say to them?
Okay, I guess that's a question. Whoever wants to take it first.
Mr. Chair and Supervisor Shea, I would tell them that every single day that the members of the public safety system are actually doing everything in their power, oftentimes under extraordinarily difficult circumstances. That starts with the police officer at the street level, and it just moves up progressively. And you're dealing with a community and, quite frankly, a society as a whole that is suffering a lot in various capacities, and therefore needs a lot of interventions and needs a lot of help. There's limits to what we can do with the resources that we do have. But again, that's not the excuse for not doing everything within our power to be more effective. One approach to it is simply to become more involved in that system. That's the premise behind my community prosecution program, where we actually put our prosecutors right in the community to identify problems and help people solve them. That's one approach to it right there. But you often hear people say that it can't be a spectator sport, but for the most part, people don't want. I mean, that's a good thing. Most people don't want to be involved in the criminal justice system, right? They want to live their lives in peace. They want to take care of their families. They want to make sure everybody that they care about is safe, that they've got opportunities. That's what they're counting on this system to help provide them for. But that system is under a lot of challenge right now. So what I would say is get involved in it, participate in it, become more understanding, and then push us to do a better job.
Chief Judge?
Mr. Chair and supervisors, I would say similar to what John said. I would also say that this body helped create the Community Justice Council. Community Justice Council has a variety of committees. Some of them have a membership of about 40 to 60 people who are all trying to make our systems better, right? The governments, the justice system are imperfect systems, but every one of those people, and there's community members, you have members from here who are on that. Supervisor Johnson sits on the executive committee. I don't think there's a week goes by that those committees don't get together to try to address very, very difficult issues about this imperfect system to make it better. And that is community input and involvement that DA Chisholm just mentioned. And there's a lot of really amazing things that have come of that, I'm sure, and we have talked about we will talk about next week at the executive committee, how we can address this issue as well. As I said before, we don't rest until we try to make things better, because we should, and we have to. So that's what I would add.
If I could just, again, I apologize, Mr. Chair and Supervisor, but again, sometimes we take criticism from various spectrums, you might say, because on the one hand, I could be accused of being soft on crime, but then the other is that I know that the reality is that our prisons in Wisconsin are full of people that have committed serious and mostly violent offenses, and that's because they have been arrested and they've been prosecuted. And so what we're saying is we're always trying to reach the medium, which is the ideal version of justice, right? Is a balancing of those extremes. But we do take the issue of interpersonal and any type of violence, any kind of threat, we take that really serious. And our prisons and our jail are filled with people that have been held accountable for those offenses. And so, one of the challenges is to get in there earlier so that things don't happen that way. And the earlier we can intervene, the greater the chances that somebody doesn't spend the rest of their life in the criminal justice system.
Supervisor Shea?
Thank you, Mr. Chairman. I just want to follow up on something my colleague referred to, and keep in mind that there's a lot of interest meeting today, and I'm sure the overwhelming majority of people are not attorneys who are watching. So I want to get back to one question. In this case, the defendant in his previous case was charged with second-degree endangering safety. Now, if he used his automobile as a weapon, which in that case he did, couldn't his vehicle have been confiscated? Or is that not allowable under the law?
No, Mr. Chair and Supervisor, and I'm sorry because Supervisor Leisden also asked, pointed that question out, and the short answer is yes. And so when we go back and we break down all of the opportunities, that'll be one of the things that has to be examined. Yeah, that's the short answer is yes. That could have been impounded.
I get back for the moment, Mr. Chair.
Okay, thank you, Supervisor Shea. Supervisor Cogs-Jones.
Thank you, Chairman. And first and foremost, I would love to give my heartfelt condolences to those family members who were impacted by the most recent event or horrific event. We are enduring trauma in our community, in our neighborhoods, across the board. And right now, District Attorney Chisholm, we are looking for rapid, realistic change, okay? My point of conversation that I would love to have with you today is more so from the time that you realized that your department was understaffed, what actions or solutions were put forth to help make up for those unfulfilled duties?
Thank you, Mr. Chair and Supervisor. The short answer is that we spend an extraordinary amount of time seeking and obtaining successfully funds to be able to perform our mission that the state simply will not provide us and has not provided. That's been bipartisan neglect for a long time. We've argued the case for decades now.
Okay.
In the last session, we actually got, for the first time in about 15 years, the governor allocated 2 additional prosecutor positions to Milwaukee. But in the same period of time, we lost prosecutor positions through federal funding. The problem is that from 1990 forward, the state is responsible for providing assistant DAs. The county provides me my support staff. So the challenge is getting a legislature that is not composed of Milwaukee, a predominant number of Milwaukee legislators to recognize the importance of having not just a fully staffed, but an adequately, the economics have to change. In other words, you can't pay an assistant DA a lower rate than you're paying the city attorney, the corp counsel, an attorney general, U.S. attorney. And that's what happens. I mean, that's to be blunt, what happens right now is that the economics simply don't work if you're coming out of law school with significant debt. So the 2 things that have to be changed are both keeping and retaining talented young civil servants, people that are committed to the community, attracting people from the community. It's a really important thing to have people that reflect the community in charge of enforcing the community's laws as well. That's a challenge as well. So across the board, we spend an enormous amount. About 1/3 of our entire attorney staff is obtained through grant funding, which requires countless hours to continue doing that. We do not come to the county and ask for attorney positions as a general rule because it's just not fair, right? I mean, you are already providing us with support staff and other resources. So this is a change that really has to come from the state. And like I said, it's just been a long-standing sort of bipartisan neglect.
I thank you for that response. However, I do believe that there could be more pressure applied. I do believe that being transparent with the community and letting them know what is going on, to have that support from the residents, from the neighborhoods, so that we can all speak to the same message. I do believe that there could be an outreach with reaching out to college students that are coming out pretty soon to help in any areas possibly to not take away so much time and effort towards the most priority and important issues at hand. For example, wanting to know why wasn't the PSA tool followed? If this is something that you pride yourself on, with you having the ultimate power to make a change and make a decision, that should have been a way to kind of look further into understanding what should take precedence over another factor. And if you know that if your department is understaffed, you have to be transparent about that. You have to work with all levels of government, reach out to your counterparts in other counties, get some suggestions, have some conversations, because the way that it has been working is not working. And we're at a point in time right now where we're having a discussion because folks have lost their lives in my community. For example, Elroy Robinson, who was struck by a car on 10th and Walnut back in July. Those are conversations that need to be had with those families, as to why it wasn't handled properly. What is going on with our system? They think our system is a joke, and they shouldn't look at it like that. They should have more respect for the work that your staff and that what you do. However, because it is not communicated, we do not know. The reckless driving in my community is out of control. That conversation needs to be had with residents. That conversation needs to be had with people who are calling my office asking me questions. So District Attorney Chisholm, I invite you to come have these conversations with the people who need to know what is going on in your department and what assistance can we be, not only from the county board, but from the community as well, to help push the agenda and getting you more funding or finding other ways. A way for us to truly work together is that we have to be transparent and we have to have the necessary conversations. And these conversations have had to been had for years. I promised the people who I asked to vote for that if I was ever at the table, that I would definitely push the agenda and have the conversations that need to be had. And this is a conversation that needs to be had, not via Zoom, not via over the phone, but in person, so that you can hear the cries, and so that you can hear the pain that these people are going through every day. I'm terrified driving. I don't like leaving my house at a certain time. There needs to be more proactive approach as opposed to a reactive approach. I am calling on all members of the state, the federal, the county, and whomever else, the residents, the community activists, to take a stand and ask for a rapid, realistic change so that we can have the necessary conversations to then have the necessary solutions from not only those of the expertise, but then those of the residents in the community as well. Thank you.
Okay, thank you, Supervisor. Let me ask my few questions. First, for Mr. Chisholm, we know that the safety assessment, the risk assessment, was not looked at in this particular case. Do you have any idea how often that happens, where the ADA is either too busy, too preoccupied, or the assessment's not uploaded? I mean, how often does that happen? Because it's a great tool if we look at it.
That's exactly right. Mr. Chair and members of the committee, this is an issue we are looking at right now. It is a concern. I mean, again, it's a useful tool. We tell everybody that a tool is just that. It does not override your professional judgment. In other words, there are times when the safety assessment may recommend something lower than we think is appropriate. If that's true, then the instruction we give our staff is that they are to use their professional judgment and make the argument, make a rational argument for why that should not be followed. But if the assessment appears based on all the information you have to be accurate, you want them to use it. So that's one thing that we're going to be looking at very closely to see if there are reasons that those safety assessments are not getting into the hands of the ADAs. I will tell you that for the most part, I think it is simply a matter of just being overwhelmed, quite frankly. But that's something we're going to look at very closely. Because you're right, it's a valuable tool.
So as we move forward, and you move forward with your, investigation, hopefully at a later meeting, we'll be able to know, again, how often that problem occurs. Mr. Reed?
Yes, I just want to give you a small point of information. When we have an initial appearance before a court commissioner, obviously both parties have access to the PSA, and I would say that it's a rare case where that's not available. And I think oftentimes, the parties are looking for it because they want to be able to make sure that that part of the bail decision or that information is given to the court commissioners. So I think it's, as a generalization, that PSA report is in almost all the hearings, and it may not be agreed to by either party, and it certainly may not be followed by the court commissioner, but I think generally speaking, it is available.
Okay, thank you.
And then, if I may again, Mr. Chair, I apologize. That's an excellent point. And what I was actually speaking to is for the ADA that's actually in the process of reviewing the case. Sometimes we try to get everything done in about 48 hours after the person has been arrested. And so sometimes that information has, but Mr. Reed is absolutely correct. At the time that the bail is set, that is generally in front of the parties. And that is another area that there was a breakage in the chain. There was another opportunity at that point in time to address it.
Next, also for Mr. Chisholm, I believe I read that there was an open warrant for the defendant in another state. I guess, first of all, is that accurate? And number two, is your office aware of those things at the time that they're asking to set a bail amount? Because it would seem to me that if there were an open warrant in another state and that we knew about it, that would greatly impact a bail request.
Thank you, Mr. Chair. My understanding is that information was not part of what is called the NCIC package, and that's actually put together by the Sheriff's Department. I think that was looked into almost immediately afterwards when reports after the name was publicly disseminated. There were reports that there was an outstanding warrant for, I think, failure to register out of Clark County in Nevada. And so I believe it's, and I'm stating this on belief, and if I need to be corrected, then the packet did not contain that information. And it's sometimes understandable because, for example, you have to make a determination whether if someone, for example, from Milwaukee fails to register, do you actually put that in the system if they're in a different state? And are you going to pay to bring that person back to your state for example, a failure to register? You tend to only extradite for the felony matter, so sometimes they're not even put in the system.
Okay. At this point, I want to go to non-committee members, board members who may have questions or comments. And we have a few, I think, that are present. So Supervisor Clancy.
Thank you, Mr. Chair. And I apologize if I falter a bit here. I'm here both as a supervisor and as the father of one of the children who was in the Waukesha South marching band and was missed by inches but saw things that no child should see. So what we're talking about here is harm reduction after harm happens, and we know how to prevent crime, and we need to do that first. But there was harm done in Waukesha. There is harm done when we remove people from the community, and I really appreciate the discussion that's happening here today. If we're going to remove people from the community, the question before us here, I think, is what the criteria should be to do that. Someone with an extensive record of domestic violence should probably be higher on that list than someone with a nonviolent offense. And D.A. Chisholm, I really appreciate you saying here clearly, as you have before in the past, that cash bail is completely inequitable. It should not exist, and I agree entirely with that. We cannot continue to incarcerate people before their trial because they're poor. And I thank you for sticking with that stance, even when it's politically difficult to hold. So I also heard you say, D.A. Chisholm, that the preventative detention framework is unworkable. And I heard you argue for a system which lets you basically argue to a judge on a case-by-case basis why someone shouldn't be put back into the community. So my questions are around that specifically. I'd like to know both how you would ensure that such a system is equitable, given that there's going to be bias and all that, I think, introduced in that system in a way that's having a computer or more fact-based things might introduce, but in a different way. And then what the obstacles are to implementing that, and separately, how we finally end the practice of cash bail entirely, because it is inequitable.
Thank you, Mr. Chair and Supervisor. Again, yes, I stand by the assertion that as written, the current preventative detention statute in Wisconsin isn't workable. Here's the good news. There are workable preventative detention statutes in other parts of the country. And it's all predicated on the concept, you can call it the 10% rule, and that is that really about 10% of the individuals who are creating a disproportionate amount of the dangerous and violent crimes, that those individuals are the ones that you should concentrate on. And there can never be a system in which the state doesn't have to meet a burden. In other words, no matter what system you set up, the state would have to have a burden of demonstrating by clear and convincing evidence, preponderance of the evidence, whatever standard you want to approach, but it would be limited to certain types of offenses as a general rule. And again, what you would ideally do is that at the same time as you're holding a probable cause hearing or a probable guilt hearing, which is what a preliminary hearing is, you could also, as a separate part of that hearing, introduce the issue of risk. And again, what it would allow you to do is talk honestly. Instead of saying, I want $1 million because I'm worried that the person isn't going to show up again. Instead, what you say is, I want the person to be detained, and then we will expedite trying this case and make sure that everybody's civil liberties are respected completely. But we believe for these reasons that this person poses too big a risk either to the victim, for example, which is what we generally are concerned about with domestic violence cases, but it can be other issues. What do you worry about with a 6th offense drunk driver? That you're generally more worried about just general, the ability to cause significant harm. So the approach would simply be putting the burden on the state to demonstrate why this person should not be released until they've had a fair jury trial or a fair adjudication. And then the rest of the individuals, it would be presumed that they would be released on whatever appropriate conditions you could find. That would be the system that I would advocate for.
I appreciate that detail and insight, and I hope this is the beginning of the conversation to make some change there. Thank you. I'll yield back.
Thank you, Supervisor. I don't see any other board members asking to be recognized, but if you are there, please raise your hand or enter so we can recognize you as part of the conversation. Otherwise, we've gone around the committee. I guess I would just at this point say again, we view this as a beginning of a conversation, and hopefully we'll continue to work together on this and other issues. I guess I would just go around the trio here for any kind of closing remarks for today. So, Mr. Chisholm.
Thank you, Mr. Chair, and members of the committee and members of the county board. I welcome the opportunity to speak to you on policy issues, on productive ways that we can improve this system, and consistent with the request from Supervisor Cogs-Jones, I'm happy to talk to your constituents face to face in person. Yeah, that's come under constraint as well in the last 2 years. But I couldn't agree with you more. That's sometimes the perceptions people have of other people change, hopefully for the better, when you get a chance to actually meet them in person.
Thanks, Chief Judge Tergiano.
Yeah, Mr. Chair and supervisors, as well as Supervisor Clancy, I didn't know that your son was involved, so my condolences, and I hope he has a quick recovery. I know traumatic events can last a lifetime, and so I'm hopeful for his recovery, as well as Supervisor Logston, your family member as well. So thank you for allowing us to present here. I'm always happy to appear in front of this committee, to report out, to seek out your help and assistance in these matters. You've been open to hearing us out and helping us in terms of what we need to make complete and full recovery here in the courts. Many of the issues we are experiencing certainly have been longstanding and have been around since before COVID. COVID certainly has exacerbated the processes we're trying to deal with, but we have all been on board, all hands on deck, trying to figure it out. We will continue to do that. We will not rest. Tragedies like these certainly are few and far between, and we want to make sure that they never occur again. And so we will do our ever best. So thank you for this opportunity to speak to you.
Thank you. And Mr. Reed?
Yes, Mr. Supervisor and others, I just would say 3 quick things. One is, I think it's really important to say that, the system that we have built that uses these risk assessment tools, that uses a lot of evidence-based practices, is something that people have worked really hard to create for Milwaukee, and we stand out in some ways among a lot of places in the country in our willingness to look at things that are proven to work. And we have regular meetings just on these release decisions once a month at least, and we look really closely at things when they don't work and when they do work. And so I think it is really important to say that this is not a shoot from the hip kind of process that we've put in place or we have here. I think the second thing I would say is that we want to have the right people in custody, the ones who really represent public safety risks. And when people get into trouble and they can come to court and stay out of trouble and address the problems that got them into that difficulty, we want them in the community, taking care of their families, getting employment, getting the treatment or the whatever it is that they need to learn from their bad experiences. Understandably, we focus on the most open and notorious cases, the ones that scare us, but the vast majority of people going through our court system are not people who scare us. They're people who have trauma histories, they have addictions, they have mental health histories, they have various problems, and they have made poor decisions in managing those things. They need to have intervention, they need to be held accountable, but they don't have to be in our jail. And if the moment that we're in mistakenly leads us to the thought that everybody should be in, or we should double the number of people in custody, it would come at an enormous cost to our community, and it would invite further disorder and difficulty, and no one wants to go in that direction. I know just so many of the supervisors don't want to see that happen, but that's a little bit of the danger in the moment that we're in, and I would like to just speak out on that. And I think the third thing I would say is that, as I indicated at the beginning, our staff, and I'm one of the people who do this, we're in these intake courts appearances every day. And I just think it would be a really flawed perception. It is a really flawed perception that decisions are being made, that are careless or that tend to disregard the public safety aspects of what needs to happen. Our lawyers probably would tell you that they see a lot of people who are low risk who are being held in custody, not the other way around. Not that there are lots of high risk people that are getting released all the time because we prevail in our recommendations that we have to make on behalf of clients. It doesn't work that way. The public safety concerns have always been I think honored in a significant way, and I just would like to give everyone that reassurance based on, as I said, a deep and broad experience with our intake court system.
Okay. Thank you. Appreciate your comments. So at this time, we'll conclude this particular item. Again, I want to thank the three of you for attending and participating. Again, our committee and our board is ready to work with you and cooperate with you as we move forward on this. I don't know if it'll be at our next meeting, maybe it'll be the one after, but at some point in the future, we'll ask you to reconvene and give us an update of what movement, if any, has happened since this particular meeting. Supervisor Logsdon?
Thank you, Mr. Chairman. I just wanted to add, we cannot go back and change what happened, but we can look forward and we can make changes to prevent this from happening again. And I want to also express my thank you for this meeting, for coming forward and joining with us and letting us ask you the questions. And I would also like to send out my heartfelt prayers to everybody that's a victim, not just the people that were hit, but the bystanders that had to view this, that will kind of be in their brain for a long time. And I just would like to just send my prayers out to everybody. Thank you.
Okay, thank you for your comments. So once again, thank you. And this item is concluded for today, and have a good rest of your day. Thank you.
Thank you.
Thank you.
Thank you.
Madam Coordinator, let's go back to our order of our agenda. So would you please read item number 1?
Item 1, a resolution/ordinance by Supervisors Weishan Jr. and Logsdon amending Chapter 13 of the Milwaukee County Code of General Ordinances to require Milwaukee County Board of Supervisors approval for all agreements and partnerships with Milwaukee County support groups. At the October 29th meeting, this file was laid over for 1